Hello class, for this week's assignment I wrote out, according to Merriam-Webster, voir dire is simply defined as a preliminary examination to determine the competency of a witness or juror. This process, it's in place to ensure that a juror or a witness is selected who is non-biased and impartial to give a fair trial. The origin of the word is French and translates to speak the truth, which is expected and enforced within the legal system. As you all know, we are sworn to an oath to tell the truth. According to Cornell law, voir dire is the process through which potential jurors are questioned by either the judge or a lawyer to determine their suitability for jury duty or jury service. It goes on to say the preliminary questioning of witnesses by experts to determine the competency to testify. A good example that they provided during our reading was the death qualifying portion. It stated the Supreme Court held that the government was entitled to voir dire in order to ensure that jurors in capital cases would be willing to sentence a guilty defendant to death. That's especially important because in those cases, death may be one of the potential outcomes. So it is important to have people in place that would be able to agree with that sentence, in order to move forward. With that example, voir dire does serve its purpose. It would, in order to improve the current system of voir dire, though, I would suggest removing the human factor. Sometimes human factor comes in and it plays a role even unconsciously. So it is important to kind of, in my opinion, I would suggest removing the lawyers and the lawyers and the attorneys from the process. Maybe have like a questionnaire. It's standard all across the board. Run it through a computer. I don't know, use technology if it's used for everything nowadays. So I'm sure there's some how to make that work. However, I know at some point there will be flaws, but at least it's not going to be biased. It's up to technology. The defendant absolutely deserves and is entitled to a fair trial, to include a jury who is fair and impartial. That's actually just part of our human rights. From what I gathered from this week's videos, preemptory strikes are based on feelings. There's usually a set amount that of these strikes that can be used. They mentioned it's between 6 and 10. And then challenge for cause comes into play once an individual has admitted to be some sort of bias, preventing the defendant from receiving a fair trial based on judgment and or consideration of any sort. That's all I got.